Hi everyone. So in this video we are going to discuss about question number 6 and 7. So if you have any queries, just note it down and mail us at ourlawworld@gmail.com and note down any answers for your reference and do share the video if anyone want to know about the answers for this AP JCJ mains examination paper. So now we are going to discuss question number 6 and 7. So coming to question number 6, what are the rights of daughter in a coparcenary property prior and after the amendment in 2005 regarding Section 6 of Hindu Succession Act? So here Section 6 is about devolution of interest in coparcenary property. So now how this coparcenary property is being held explained before 2005 Act and after 2005 Act. So what are the differences and what are the rights that a daughter has claimed? So before 2005 regarding section 6, we can term this as limited rights. So here daughters don't have equal rights in ancestral or coparcenary property, and this is excluded. So here daughters have limited rights only. But after 2005 amendment, what happened here is equal coparcenary rights are being given to the daughters as well as equal to sons by birth. So you can term here as coparcenary property by birth, even they have got a equal interest as how the coparcenary property is being given to the sons. So before 2005 it's a limited right, and after 2005 it has become a equal coparcenary right. And one more difference is before the amendment, here it is considered in class 1 heirs. So daughters are considered in class 1 heirs and they get the coparcenary property only if a male person is absent. That means in the absence of any male coparcenor, then only in class 1 heirs the daughters are eligible to get the coparcenary share, or the daughters could inherit their father's property, but the share was not at all equal to share of sons or male heirs. So if there is no male heir, that means if there is any absence of male member, daughters used to get coparcenary property but not as equal to male heirs. They get only a partial share. But here, nothing like that. So the entire situation has changed. So here the equal share, as said before, in coparcenary property as is being given to daughters also as how males are treated, even though it doesn't depend on the absence or presence of male members, the daughters are also having equal share here. It doesn't depend on any separate share, only in the absence of male. It is depending on their amendment act which has been brought up the equal rights in the share which they can take. The next one, here daughters had right to maintenance from their father's estate. But they do not have any ownership. So here you can also term this as daughters are having the maintenance right from their father's estate, but they do not have any same sort of ownership rights which have been given to the sons in ancestral property. But here right to demand for a partition has been given to daughters also in the ancestral property, and daughters not only get the rights, they should also take the liabilities, duties, rights in equal as to sons. So this is the scenario, and this amendment act 2005 is treated as retrospective retrospective in nature, which is regardless when in which year they are born. This act applies to before year daughters who are born before to this year and after to this year. That is called retrospective in nature. So this is the basic difference for before 2005 Act and after 2005 Act. So now going to seventh question. Explain what is constructive res judicata. So mostly in most of the papers we are seeing this question. Explain what is constructive res judicata. So everyone knows what is a res judicata, right? So res judicata means, so this has been termed under section 11 of CPC, Civil Procedure Code. And both these doctrines like res judicata and constructive res judicata, these doctrines are to give finality to the judicial decisions and their effect on subsequent litigation. So these doctrines help to prevent relitigation. So they don't want to waste the time, court's time. So to prevent the relitigation, these doctrines are helpful. So in Latin term, res judicata basically means a matter which is already judged. So what is the basic criteria? So the basic criteria for the doctrine of res judicata is it applies where a final judgment has also been delivered. So where the matter is adjudicated or the final judgment has been delivered. And it should involve same parties with same subject matter. Same subject matter with addressing the same cause of action. So a matter when once decided and adjudicated, this cannot be subsequently present in the court again as a other suit. So this is called as doctrine of res judicata. Constructive res judicata is also called as collateral estoppel. Collateral estoppel, or it can also be termed as issue preclusion. So this doctrine is also nothing but same. So this also states about it prevents the re-litigation of specific issues and facts. So this prevents re-litigation of specific issues and facts. So if you go into section 11 of CPC, there are certain explanations which are being mentioned in the Bare Act. So you will have up to 8 explanations. Go through the 8 explanations thoroughly, which has been given clearly under this section and it has been defined clearly. So out of this, explanation number 4 is termed as constructive res judicata. So explanation number 4, constructive res judicata, states that any matter which might and ought to have been made a ground of defense or attack in former suit, this shall be deemed to have been a matter directly and subsequently in issue. So the matter, so in res judicata, we'll be taking the constant matter in issue. And explanation 4, the constructive res judicata states that any matter which is a ground for defense or any attack. So if any matter is taken as a ground for defense in the former suit, it is taken or it is termed as a directly and substantially in issue with such suit. So this is constructive res judicata. So we'll get back to you in continuation with the next video. Do not forget to subscribe if you are a new joiner.